All right, good afternoon and welcome to this month's In the Boardroom where we're going to talk about parliamentary procedure. A couple of housekeeping issues. First is this is designed to be an interactive process where you have the ability to ask questions in real time as we go through the presentation. And of course, the better we are at responding to questions in real time, I think the better the learning opportunity for everybody. So absolutely feel free to ask questions. In order to do so, you can either use the Q&A button or the chat button on your screen. We will see those questions as they arise, and we will do our best to get to them when you post them. This presentation, along with the slide deck, will be posted to WCA's website, wicounties.org. Upon the conclusion of our discussion today, it usually takes a couple of hours for that presentation to be uploaded through Zoom and get to WCA's website. So please be patient if it's not until tomorrow morning. That's because there was a lag in the process of getting it uploaded from Zoom. So if you are desiring additional information or even want to share the presentation with others, that's where you go, www.wicounties.org under past event materials. I'm Andy Phillips with Attolles Law, privileged to serve as general counsel for the Counties Association. I've had that position for the past 20, 25 years thereabouts. And today's discussion is really talking about, it's titled The Elegance of Parliamentary Procedure, but I really want to get into some of the procedural rules surrounding parliamentary procedure so that you, as a listener on this, are equipped to, number one, make sure that you understand what's going on in a meeting, but then number two, you are able to take particular actions and utilize parliamentary procedure to accomplish what you need accomplished in a meeting. So today's discussion is not a how-to guide. I'm not going to tell you exactly how you do every single motion or objection or point of order within parliamentary procedure. There are how-to guides that are out there. I'll talk about those in the context of today's discussion. But today is really to give you the ground level information to utilize parliamentary procedure in the best way that you know how. So without further ado, let's talk about parliamentary procedure. We have basically 5 different topic areas that we want to cover today, and time willing, we're going to get to all 5. We're going to talk about running effective meetings. We're going to talk about types of motions. We're going to talk about boardsmanship and rules of decorum. We're going to talk about certain motions and misconceptions associated with those motions. Then we're going to talk about the public comment period. So when we talk about running effective meetings, we want to set the stage. This is really, really important. I know that I've talked to you on several occasions. I know that Sarah has talked to many of you on several occasions about the importance of board rules. Board rules are important because if there is a certain procedure that you want to utilize, whether it be in a county board meeting or a committee meeting that is different from what's contained in Robert's rules, you have the opportunity through board rules to modify what Robert's rules may require. However, there's only so much that we can do with board rules because our board rules cannot modify state statute. And so when we think of order of precedence, first we have to comply with state statute, then we have to comply with our board rules, then we go to Robert's Rules of Order as it relates to questions of procedure. I'll give you an example. Robert's Rules of Order obviously does not incorporate Wisconsin's open meetings law, but Wisconsin's open meetings law says that we have to post our agendas or notice of our meetings at least 24 hours in advance of a governmental body's meeting. We cannot modify that through board rule. We cannot modify that through Robert's Rule. So even though Robert's Rules doesn't address it, and our board rules, if it did address it, it has to comply with Wisconsin state statute. So again, we have to deal with order of precedence as it relates to state statutes, then board rules, then Robert's Rules of Order. So I want to first talk about why. I want to talk about the why, because if we have an understanding of the purpose of Robert's Rules of Order, the purpose of parliamentary procedure, hopefully, as we go through this discussion a bit further, a light bulb will click in your head that says, oh, that makes sense. That's why that rule exists the way it does. That's why, for example, we have a supermajority vote requirement on a particular motion. It's because of the why. So let's talk about the object of the Rules of Order first and foremost. Again, this is taken from Robert's Rules of Order newly revised. So when we look at the object of the rules of order, it's to facilitate the smooth functioning of the assembly, to provide order for these meetings. It provides a solid basis for resolving questions of procedure. They provide organizational stability. And it's important, and I've seen this in board rules and other ordinances throughout the state, in county government and municipal government and school district government, where they simply adopt Robert's Rules of Order without specifying the addition. There is an update that comes out to Robert's Rules once every, I don't know, 4 or 5 years thereabouts. Right now, we're on the 12th edition of Robert's Rules, newly revised. So I imagine another couple, 3, 4 years, it will be the 13th edition. So what we always want to do is in our board rules, adopt the latest edition of Robert's Rules of Order, newly revised. Now, you'll see in this bullet point, these bullet points, that the item on the fourth bullet point, provides organizational stability. One of the things that I think we desire when it comes to county board meetings or committee meetings is that there are no surprises in terms of how those meetings are run. And so in promoting a solid set of procedural guidelines, we are promoting stability and predictability as to how those meetings transpire. That's important for county board supervisors, but from my perspective, it's also important for the public. What do I mean by that? What I mean is that it is a lot easier for us to function as county government with an electorate or a public that has full faith and confidence in how it is that we conduct our business. One of the ways that we can instill faith and confidence with the public is to run our meetings according to a consistent set of procedural rules so that we can display efficiency, so we can display effectiveness. And so think of Robert's Rules of Order, your board rules, and frankly, parliamentary procedure as an opportunity to display to the public that we in X county do things the right way. So again, when we think about parliamentary procedure and the purpose, the object of parliamentary procedure, we've got these bullet points. And to me, this is more than just simple purpose statements. These are critically important to our understanding of those rules. So what are the principles that are underlying parliamentary law? Let me back up for a little bit, and I'm not a historian, and don't quote me on any of this because I don't want anybody coming back and saying Andy Phillips said this, this, and this, but I want to give you a summary understanding of the source of parliamentary law. As you might imagine, parliamentary law dates back centuries, goes back to Old England, and in fact, their legislative body in England is called the Parliament. So parliamentary law dealt with the way that the English Parliament conducted its business. Of course, when the British established the colonies in the United States, they also imported all of their customs associated with parliamentary law. And so, for example, when the Continental Congress met back in the 1770s, they utilized parliamentary law that existed from England or Britain as it relates to the conduct of their proceedings as a Continental Congress. And if you look at the way that the Continental Congress conducted itself, it was similar to the way state governments at the time that states were formed conducted themselves. It was similar to the way then that all local governments conducted themselves, consistent with these principles of parliamentary law. Then we had other organizations that were also utilizing a lot of the principles that were in parliamentary law. Now, there are several sources of parliamentary law that have existed for quite some time, but right now, today, the preeminent source of parliamentary law is, of course, Robert's Rules of Procedure. Robert's Rules of Procedure were not written until the mid 1800s. All right. So you think about it, our country was almost 100 years old before Henry Robert committed his rules to writing and codified them in Robert's Rules of Order. Not necessarily important for our discussion, but if anybody's interested in useless trivia, Henry Robert was in Milwaukee, Wisconsin when he wrote the first draft of Robert's Rules of Order. And you might think to yourself, well, what was he doing in Milwaukee writing Rules of Order? He was an engineer and he was involved in, I believe it was shipbuilding at the time. And he found himself stranded in Milwaukee in January. And anybody who's been to Milwaukee, or for that matter, Wisconsin in January, knows that the weather can take a quite cold turn in January. And so, what better thing do we have to do than sit by a fire and write rules associated with procedure for government and organizational meetings? So, that's your useless trivia background, is that Henry Robert wrote Robert's Rules in Milwaukee, Wisconsin on a very series of cold days, a series of very cold days. So we look at the principles underlying parliamentary law. Okay, so why do we have these rules of procedure codified within Robert's rules, and what is the purpose of having these rules? All right, we talked a little bit about the object before. Now we're getting into a little bit of the nitty-gritty as to why the rules sit in the position that they sit. The rules are based on the regard for the rights of the majority. So in typical situations, the majority rules on any particular question coming before a deliberative assembly, and that's what Robert's Rules calls a body in this circumstance, is a deliberative assembly. So we rules based on the regard for the rights of the majority, but also we recognize the rights of the minority, especially a strong minority. We recognize the rights of individual members. We even recognize the rights and do things within our procedural rules to preserve the rights of people that are absent from a meeting. And then we have all of these together recognized within that set of Robert's Rules. And so, again, this provides a fundamental understanding of why it is that certain rules read the way that they do. So the first question is, how do I get an item of business before the body? I don't care if it's a motion, a resolution, whatever. How do I get that before the body? What do I do? And if we look at Robert's Rules, it's an 8-step process. Within the slide deck, I have commentary on each of the 8 steps. I'm not going to get into specific commentary on each of the 8 steps within the slide deck. I want to talk about it here while this is on the screen so that we have an understanding of all of these 8 steps in real time as we go through this process. So if you want additional information, feel free after this discussion to download this slide deck and take a closer look. But I want to I'm going to keep this slide on the screen for right now. First, we have to obtain the floor. Typically, in county board meetings, now that most counties have adopted electronic voting, we press the button on our electronic voting device that says, I want the floor. The chair recognizes that person as wanting the floor and calls on that person. In counties that have not adopted electronic voting, you obtain the floor in a variety of different ways. According to Robert's Rules, you are supposed to stand until the chair recognizes you. But what I've seen done in other counties is raising a hand, asking out loud, Mr. Chair, Madam Chair, whatever the case may be, but there is a process for obtaining the floor. If you do not have electronic voting, I would highly suggest that we codify within our board rules how it is that a person obtains the floor. Because frankly, I don't want to see 15 different ways of doing it. I want to see one consistent way of obtaining the floor. Once that member obtains the floor, that member doesn't start engaging in debate on nothing that is pending before the body, because if nothing is there, there is nothing to debate. We first have to have an item of business on the board floor. In order to get an item of business on the board floor, that member has to make a motion. Mr. Chair, Madam Chair, I move that, whatever it is that is being moved. Once that motion is made, it has to be seconded. So there has to be at least one other person in that meeting that supports that item of business being on the floor of a board or committee meeting. So it's not until that motion is seconded that anything needs to happen with that motion. If the motion is not seconded, what happens to that motion? It dies for lack of a second. All right. So a motion has to be made. It has to be seconded by somebody who didn't make the motion. And then the 4th step is a really important step. And I see this step skipped every now and again, and it frustrates me, because this is a really important step, and it speaks to the role of the chair of these meetings, whether it be board chair or committee chair. And it's a very important duty of the chair. The chair then restates the motion. Why is the chair restating the motion? Because that motion is going to belong to the body, the county board, the committee, whatever the case may be. Once it belongs to the body, the body's going to debate that particular question. The body has the opportunity, or members within the body have the opportunity to amend the motion, to do different things with that motion. So before it belongs to the body, we ought to make clear what that motion does. The way we make clear what that motion does is by having the chair restate the motion. It's at that opportunity that the chair can ask a question of the maker. Does this adequately reflect the motion that you've made? And if not, what are the particulars in terms of how I describe this? What are the particulars of that motion? So do not skip that step. The chair restates that motion. As I mentioned, once the chair restates that motion, it becomes, it's owned by the body. It becomes something that the body has authority over. So that's where the members of the body engage in debate. We're going to talk about various motions that can be made when a motion is pending. We'll get into that in a moment. But again, the body owns that motion and the members debate that motion. Once debate is done, and there are a couple of different ways that debate ends, but one of the ways it can end is when nobody else is requesting an opportunity to speak on the motion, the chair is going to put that motion to a vote. And so we want to find out, is this motion going to be adopted? When we think about, is this motion going to be adopted? Remember how I talked about the importance of step 4 with the chair restating the motion so that the body understands exactly what the motion says and does. When it's getting put to a vote, it's really, really important that the chair again state what the motion does, and then also explain the consequences of a yes vote and the consequences of a no vote. We want to make absolutely clear what it is that the body is going to vote on, and what it is a yes vote means, and what it is that a no vote means. So again, importance of the duty of the chair, whether it be county board or committee, the chair has that obligation to ensure that the body understands what it's voting on. Then we have the members vote, and in counties that utilize an electronic system, that means that we're pressing buttons again on our panel. In counties that don't, there are a variety of ways that votes can be taken. The typical way in Robert's rules is by voice vote. And so the chair is going to ask all those in favor, signify by saying aye. We'll listen to who votes. All those opposed say nay. We again listen to those votes. And then the chair announces whether a particular motion is adopted or defeated. Now, any member can request that there be a roll call vote. Any member can request a showing of hands. This is an example of, again, if we think about the reason behind some of these procedural rules is to ensure that we have validity in the outcome of the vote. So if there are all sorts of people that say aye and then all sorts of people that say nay, and the chair says the nays have it, the vote is defeated, somebody can request that we have a showing of hands or a roll call vote to again reinforce the outcome of that particular voice vote. So there's an entire chapter in Robert's Rules devoted to this concept of voting. And to the extent you want additional information on how voting occurs, take a look at that chapter within Robert's Rules. Once the vote happens, the chair again announces the result of that process. Now, I talked about in step 4, step 6, partially step 7, and again in step 8, the important role of the chair of the board or the committee. It is an incredibly important role, but the chair does not exist on an island. There are people within that meeting that are there to assist the chair. The primary person that is going to assist the chair is the parliamentarian. Typically, we see the corporation counsel appointed as parliamentarian over county board and committee meetings. In other words, the corporation counsel is going to confer with the board chair on questions of procedure. I want to emphasize this point because I've seen mistakes made over and over and over again. When questions of procedure arise, when procedural irregularities arise, I see folks really, really anxious to get to a result, to answer the question, to make a determination. Don't let that anxiety, don't let that pressure to get to a quick answer overwhelm you. Rely on the people that are there to assist you as board chair. Allow the parliamentarian to weigh in and take the time to get to the correct result as opposed to a quick result. So again, those are the 8 steps on business coming before the body. There are all sorts of additional points within the slide deck that I am not going to discuss today, but when you download the slide deck, if you have any questions about this, please reach out and we'll be happy to answer any of those questions. So I had a question from Joe. The parliamentarian gives advice. They do not issue rulings. That is entirely correct, Joe. And I hopefully made that clear before. The parliamentarian is there to assist the chair in making a ruling. It is the chair's responsibility to rule on questions of procedure. We're going to talk in a moment if the body disagrees with the chair's ruling, but I want to make clear to Joe's point that the parliamentarian is there in an assistant role to assist the chair in making those determinations. Now, let's talk about what types of motions exist. There are basically 5 different categories of motions within Robert's rules. And again, once we understand what categories different motions fall in and the reasons behind these motions, hopefully that light bulb is going to go off and you're going to understand a little bit better why Robert's rules treats certain motions in certain ways. There are main motions. A main motion which is not described in Robert's rules is called an original main motion. Why is it not described in Robert's rules? Because there are literally millions of different original main motions that can be made. So when I think about county government and a county board, an original main motion might be, I move that we purchase a new truck for the highway department at a cost not to exceed $120,000. That is an original main motion. That highway truck motion is not going to show up in Robert's rules because it deals with a matter of business, not a matter of parliamentary procedure. So again, main motions, original main motions, those deal with items of business. Subsidiary motions, those types of motions assist the body in handling some other type of motion. The motion to amend an original main motion is a subsidiary motion. So for example, in the highway truck example, if that original main motion is pending, you can move to amend that to say that it be a red highway truck, inserting the term red before highway truck in the motion to purchase that truck. So that would be considered an amendment and it would be a subsidiary motion. Next, we have privilege motions. Those deal with pressing questions that aren't directly relevant, directly pertinent to the question pending before the body. For example, a motion to recess for a brief period of time. That would be a privilege motion. And then that recess motion is dealt with. And depending upon the outcome, the body takes action, then returns to the original main motion in the amendment if that original main motion has been amended. We have incidental motions. They affect how a body considers or deals with an original main motion, the question that's currently pending before the body. For example, a motion to suspend a board rule, a motion to suspend a rule of parliamentary procedure. Those are 2 examples of incidental motions that aren't directly related to the business that's pending, but impact how it is that the body deals with the business that's pending. And then finally, we have restorative motions. These are motions that bring business back before the assembly, not assembly, back before the body that have already been disposed of by that particular body. So for example, a motion to reconsider would be a restorative motion. All right, so we've talked about main motions. I want to talk a little bit about the different motions that fall in these various categories a little bit. Subsidiary motions, as I mentioned before, they dispose of other business pending before the body. There are 7 subsidiary motions. There's the motion to postpone indefinitely. The motion to postpone indefinitely is a procedural tool to cut off debate and allow the body to dispose of a particular main motion without actually reaching the merits of that main motion. You don't have to vote yes, you don't have to vote no on that main motion if on the motion to postpone indefinitely that motion is carried, all right? That requires a majority vote. And just as the name suggests, the motion to postpone indefinitely means we are never going to take it up again during this session of the county board. And let me pause there because I just talked about this concept of a session of the county board. A session is usually defined in Robert's rules as a meeting. All right. Robert's rules isn't always a precise fit for governmental bodies. What I mean by that in this circumstance is that when I think of session, and I think for that matter, when most people think of a session of a county board, we think about the 2 year period between the organizational meeting in an even numbered year and ending on the next organizational meeting in the next following 2 year period. Why do we think that? Because the term of office for county board supervisors is 2 years. And so we think of new county board, new session of the board. That is not defined in state statutes. It's not 100% clear within Robert's rules that that's how a session may be defined. So that's an area where I would really encourage counties within their board rules to define session. In the board rules say that the session is that 2 year period between organizational meetings. When you do that, that definition is then going to carry through on all procedural questions that arise. What do I mean by that? For example, postponed indefinitely. When we say something is postponed indefinitely, it can't come up for the entirety of that session. That means for that 2 year period. Once that session expires, that item of business then is in order for presentation back to the board. So again, let's define session if we can. The motion to amend. That's the most common subsidiary motion, and that's actually the motion that I utilized as an example in discussing the point of subsidiary motions. That is used to offer a change to the motion that's currently pending before the body. Understand that only two motions to amend are in order at any given time. So your original main motion, it can be amended, and that amendment can be amended, but then another amendment is out of order until we dispose of that second amendment. Okay, so when we think about it going down the ladder, it's two rungs. That's it. Two motions to amend. That's all that's in order at any one time. The motion to commit or refer to a committee, that means that we can take an item of business pending and hand it off to a committee, and then that committee is to take action on that particular item. To move the previous question means that we are going to cut off debates. A lot of counties out there, I've heard in board meetings say, members say, I call the question. There's no such thing in Robert's rules as calling the question. It's moving the previous question. Now, this is an example where, if you remember at the outset of my discussion, I say that there is an aspect of parliamentary law and Robert's rules that is designed to protect the rights of the minority. Debate is a really important concept within Robert's rules, and frankly, it's an important concept within our representative democracy, is that we want a fair and open debate. So if we are going to cut off debate, we ought to have a supermajority vote to cut off debate. So moving the previous question, calling the question, it requires a 2/3 vote in order to be adopted. There is a motion to postpone definitely. That means we are going to stop consideration of this item of business until a future date or time. And so that's the motion to postpone definitely to a definite time period. This motion is often confused with the motion to table. I've heard that in counties too. I move we table this to the next meeting. Well, it's not really tabling it to the next meeting. We're going to talk about that in item 7, what the motion to table is. It's really postponing to a definite time. So let's, again, try to use the correct terminology when it comes to making these subsidiary motions. We can move to limit or extend the limits of debate. We may have within Robert's rules or our board rules a limit on the amount of times that we can speak, or the amount of time within those times that we can speak. So we may want to amend those rules in order to allow for a greater conversation. Then finally, we've got lay on the table. A motion to table temporarily sets aside an item of business so that the body is empowered to take up another more pressing issue. Once that more pressing issue is disposed of, then the motion to remove from the table and bring it back before the body is in order. Again, don't confuse the motion to lay on the table with the motion to postpone definitely. Then we have this concept of privilege motions. Again, as I discussed before, these are motions that are used to address issues that are not directly related to the business or how it's conducted, but nonetheless, they are motions that can be made in many times, while a particular item is pending before the board. There are five privilege motions. Number one, call for the orders of the day. That means that somehow the body has deviated from the printed agenda and we want to bring the body back to the printed agenda. And so a member of the body may ask the chair for a point of order, call for the orders of the day. Unlike other motions, which require a motion and a second, a point of order or calling for orders of the day, it is required upon demand of a single member. All right. Call for orders of the day is on demand of a single member, and the chair then brings the meeting back to the business that's pending. A member can raise a question of privilege, and that just relates to consideration of relating to the rights of the body or some members. And what we mean by that is a question of privilege is that if we want to ask to be excused for a particular amount of time or something like that, we can raise a question of privilege, and then it's up to the chair to determine whether that privilege is going to be granted. We can move to recess a meeting for a period of time. Again, that's a temporary stop in the meeting so that people can, for example, use the restroom, get a drink of water, whatever the case may be, and then reconvene in 10 minutes. It's often used in meetings that run for a long period of time. A privileged motion, the motion to adjourn, all right? That means that we want the meeting to end completely. It only requires a majority vote. I have seen board rules that say that a motion to adjourn while the agenda is not complete requires a supermajority vote, and that's okay if you put that in your board rules. But in normal circumstances, under Robert's rules, the motion to adjourn can be made. It's a privileged motion. We're going to talk about motion rankings in a moment, but you have to deal with that right away, and it only requires a majority vote. If that motion is adopted, the meeting ends. In addition to the motion to adjourn, you can make a privileged motion to fix the time at which to adjourn. You can, for example, in the middle of the meeting, looking at the agenda, say, boy, I want to try to move this along. Mr. Chair or Madam Chair, I move that we fix the time to adjourn this meeting at 10 o'clock p.m. If that motion is adopted, once you hit 10 o'clock p.m., it's automatic. The meeting is adjourned. No other action is necessary. So again, you can fix the time at which to adjourn. Then we have incidental motions, and there are 15 of these, and I've talked about them a little bit so far, but I want to point these out. And I also want to point out some of the inconsistency in my mind here when we're dealing with this. When I think of motion, I think of move and second. When we get to these what are called in Robert's rules incidental motions, they're really not move and seconded type motions. They're more or less things that individual members can bring up at any point in the meeting. All right. So number one, a point of order. I talked about this before. If you have a question about what's going on the agenda and you don't think things are moving according to how you think things ought to move, you can raise a point of order with the chair. No vote is taken. The chair has to respond to your point of order and answer your question. We can appeal the ruling of the chair. If the chair makes a particular decision, the body can appeal that ruling and by majority vote can overrule the chair's ruling on a particular issue. Joe brought up the issue before that the parliamentarian assists the chair in making determinations. If the chair makes a determination, announces that determination, and you disagree with it, you can appeal that determination. We can move to suspend the rules, whether they be Robert's rules or our own board rules. I want to be careful here, though, that your board rules may have a particular rule about suspension of rules. So we have to follow that rule within your board rules about suspending those rules. It requires a 2/3 vote under Robert's rules, but it may be a different vote requirement within your board rules. So again, take a look at your board rules about how we suspend those rules. Frank had asked a question. I want to just briefly pause. Please explain the session in number 5. And I think that's going back here to fixing the time at which to adjourn. And I'm not quite sure, Frank, exactly what you mean about its relationship to fixing the time at which to adjourn. The concept of session, though, is defining the term within your board rules so we have an understanding of exactly when business is going to be in order or out of order. There's this concept called the settled rule. The settled rule says that if we have already disposed of an item of business during the current session of the board, it is out of order to reintroduce that item of business at any other meeting during that session of the board. Again, once that session ends and a new session starts, then the settled rule is not going to apply because it's new business. You can bring that business back before the body. But again, defining that session is really important. We can object to the consideration of a question. What that means is an item is introduced that we think is so toxic that we don't even want the body to debate. A member can object to the consideration of a question. It requires a 2/3 vote in order for somebody to essentially prohibit the body from debating on a particular question. We can move for division of a question. It's to separate an original main motion into two or more motions to be considered separately. That can only be applied to original main motions or amendments to those original main motions. The division of a question motion is very similar to the motion to consider something seriatim, and that's a Latin term that means by particular topical area. So, again, division of a question. All right, Kathy asked a question. I want to get to this question now because it gets to this concept of suspending the rules. Can you provide an example of when it would be appropriate to suspend the rules? If the rules are suspended, is there something that replaces it to organize and control the meeting? What I will say is that I have advised counties on the suspension of rules from time to time. It's rare, but I've advised counties on that from time to time when we see some sort of procedural irregularity that we want to cure. And that procedural irregularity may have happened in the current meeting or it may have happened in a previous meeting. And we want to make sure there's a clear record of exactly what the body adopted or did not adopt, ordered or did not order. So we will adopt a motion to suspend the rules to allow a particular matter to proceed in that unique instance. There is no motion to reinstitute the rules after that. It's just a temporary suspension of the rules to take up an item of business. In my estimation, is to make it a very clean record. I talked about consideration by seriatim, division of the assembly. I talked about the voting process. A motion division of the assembly is usually used to question the results of a voice vote. It's always on demand of a single member. So if there's a voice vote and the chair says, for example, and the ayes have it, the motion is adopted. Mr. Chair, Madam Chair, I call for division of the assembly. It's at that point that the chair then has to ask for a showing of hands, a roll call, or some other method to determine the outcome of that particular vote. Motions related to the manner of voting, I've talked about those before. Motions related to nominations, the method of taking nominations, to open or close nominations. One of the things that I see happen all the time is that if we have a nomination for a board position, for example, say it be vice chair, and there's only one nominee, it would be in order for somebody to make a motion to close nominations and cast a unanimous ballot in favor of the particular nominee. That is, again, one of the motions related to nominations. Request to be excused from a duty, and then that one's not used very often. I can't recall that ever coming up in a meeting, frankly. But then we have number 11, and this to me is really, really important. Remember, I talked about this whole concept of orders of the day and a point of order. Look at point of order. It can be raised by one particular member. It doesn't require a second. Point of order, Mr. Chair, Madam Chair. Aren't we supposed to be on item 7 of the agenda? Then it's up to the chair to make that determination. A parliamentary inquiry is a very important concept because it gives you, as a single member of the board or a committee, the ability to ask a question of procedure. All right. So if you get confused, you don't know what's going on, you shout out, Mr. Chair, Madam Chair, I have a parliamentary inquiry. And then you ask your question. There's no vote. The chair usually answers the question, or in certain circumstances may refer it to Corporation Counsel as parliamentarian to provide the explanation. But that is an incredibly important tool. It's there, it's designed to make sure you're not scratching your head on these meetings, not understanding what to do. Same thing with point of information or request for information. If you find yourself in the dark on a particular issue and want additional information, raise that point of information. And then request for permission to withdraw or modify a motion. It's used by the maker to withdraw or change a particular motion. Remember, if the motion has been restated by the chair, that motion belongs to the body. It belongs to the board or committee. That motion cannot be withdrawn or modified without permission of the body. All right. If the chair has not yet stated the motion, the maker can modify that motion. It's going to require a new second, but at that point, before it's been stated by the chair, it doesn't belong to the body. All right. So again, incidental motion request for permission to withdraw or modify a motion. Question from Sue, does Robert's rules address consent agendas? It does. It talks about the consent agenda, and some call it a consent calendar. And if you look at Robert's rules, that's a way to put several items of routine business under one agenda heading, and adoption of that particular agenda heading is going to adopt all of those routine items of business falling under that agenda heading. And the question is, can a chair elect not to allow removal of an item for separate consideration? The chair can certainly do that, but it would not be appropriate according to Robert's rules. And so Robert's rules says that anybody can move to take an item from the consent calendar or consent agenda and deal with it individually. That's a motion that can happen with consent agendas. If the chair says, I decline to do that, the recourse for the body, for the board, is to have a member say, I appeal the ruling of the chair. And at that point, the entire board decides, and again, it's a majority vote requirement, whether the chair is correct or incorrect. So that's how we deal with those consent agenda items. Another incidental motion, request to read papers. Typically, we don't want people just reading things in front of the board. They have to, in debate, talk about their own comment, not what somebody else has written. So there is a motion for request to read papers. And then there is another incidental motion about request for other privilege. Now, Kim asks a great question, and I want to get to this now because I think I have a slide on it, but I want to make sure we have time. Can we address friendly amendments? Look through Robert's rules, do a search, and find the term friendly amendment. It doesn't exist. It's not there. There is no such thing as a friendly amendment. So get that out of your vocabulary, all right? It doesn't exist. The appropriate way to deal with the so-called friendly amendment that we're dealing with here is that once the chair restates the motion and it belongs to the board, then we go to item 13 on incidental motions, request for permission to withdraw or modify a motion, or the person who is going to offer the friendly amendment just moves to amend the original main motion. Either way, it's up to the body to decide whether we are going to allow that to happen. So no such thing as a friendly amendment. There's no such thing as somebody saying, hey, do you mind if I just suggest to you that we reword this? Nope. Once that motion belongs to the body has to deal with how we dispose of that particular motion. Then we get to this concept of restorative motions. As I mentioned at the outset, these are ways to bring items of business that have previously been disposed of back before the body. There are a series of restorative motions. We can rescind something that's been previously adopted. We can amend something that's previously been adopted. Those two motions are dealt with, I believe, in the same chapter under Robert's rules. And an important concept here is that if the body, in this instance, it would be the county board, if the county board has directed certain action be taken as a result of an original main motion and the county acts on that, whether it be administration, staff, or otherwise, they act on that, at the next meeting, you can't rescind or amend what has already been authorized. So you cannot rescind or amend something that's already occurred. But you can amend or rescind something where no action has been taken in furtherance of that particular item of business. All right. It requires a 2/3 vote in both circumstances, but we have to remember that there are open meetings law considerations here. If the agenda does not contain any sort of recognition that we are going to consider a motion to amend or rescind action previously authorized or adopted, then we cannot vote on a particular item to amend or rescind. All we can do is ask that it be placed on the agenda for consideration at the next county board meeting. That brings me to the motion to reconsider, which I see come up all the time. There are very important considerations here with the motion to reconsider. First consideration is that the motion has to be made by somebody who is on the prevailing side of a question. So if the question was adopted and we want to reconsider that particular question, somebody who voted yes has to be the one to reconsider. It's not somebody who voted no on that. That's rule number one. Rule number two is that it has to happen at the same meeting or at the next meeting. That's what Robert's rules says. Here's the problem. We've got the open meetings law to deal with. So if we don't have it on the agenda, we cannot take action on it without violating the open meetings law. And so I would really encourage counties to really look at their board rules and define when it is that somebody may make a motion to reconsider and how it is that that item gets on a county board agenda. That's really important in my mind, is defining that within our board rules, because this is a circumstance where Robert's rules just doesn't jive with the open meetings law. So let's do that. Dawn asked, is a motion for consideration required? A motion for reconsideration, I think, is your question, Dawn. And yes, a motion to reconsider something that has already been adopted, that motion would be required. It requires a 2/3 vote. And it can only be made by, or excuse me, it's a majority vote, and it can only be made by somebody who is on the winning side of that. The motion to take from the table, as I mentioned before, don't confuse that with the motion to postpone to a definite time period. A motion to table is to put something aside for the current meeting and then eventually bring it back before the body. The motion to discharge a committee, this is a big one too, and I've had several conversations with several of you, which is related to this concept of something dying in committee. Remember, the county board always controls the committees. The committees are a subservient entity underneath the county board. And so ultimately, if the county board wants to consider something, there has to be a mechanism for the board to pull something out of the committee when the committee is just sitting on it and hoping that it dies just through lack of action. Well, that's something that the board can utilize, is the motion to discharge a committee, to bring it back before the body. It's been referred to the committee. We want to get it back out of the committee and before the body, because the committee is not taking action on that particular issue. That's fine. That's the motion to discharge the committee. But again, we have open meetings law considerations here. And so we want to make sure it's on the agenda that that's what the board is going to do. While we're on this topic, and you see this in all of these restorative motions, that we have open meetings law considerations. As I mentioned before, Robert's rules doesn't do a good job of coordinating with the open meetings law. And so I want to bring up a very important concept here, is that if at the end of a particular meeting, before the meeting is adjourned, a member makes a motion to place something on the agenda for the next scheduled meeting, that motion is going to be in order. And if that motion gets a majority vote, then the agenda for the next meeting is going to contain the item that was moved to be included on the next meeting's agenda. Important consideration for open meetings law, though. We cannot debate the merits of that motion. We can't, because there is nothing on our agenda suggesting that we were going to debate the merits. And so it's really important that that motion be confined to placing it on the next agenda, and that the discussion as to whether it's placed on the next agenda not get into the merits of the motion that is set to be placed on the agenda, if that makes sense. All right, so we've got the restorative motions. Now, there is a cheat sheet that is contained either within the packet. It's in the packet, I believe, Sarah. You can correct me if I'm wrong. The packet that you mailed to all county board supervisors, you send it out every 2 years with the county officials handbook. That cheat sheet contains a card ranking the various motions, what's going to be in order, what's not going to be in order, can a motion be debated, can it be amended, and what's the vote required. We put this together years ago based upon the chart that's contained within Robert's Rules of Order, as a cheat sheet guide for county board members and, frankly, for chairs, corporation counsel, clerk, and others to determine exactly the rules of procedure in Robert's Rules. So I'd really, really encourage you to find this card and keep that card in the drawer underneath the desk of your county board chair. All right. We've got a limited amount of time, and I know that we've talked in past sessions about boardsmanship and rules of decorum or debate. So I'm not going to spend an awful lot of time on this one, but I do want to highlight a couple of really important points. As we go through this and we see what the various rules are in Robert's rules, we see that there are all sorts of pointers, if you will. Remember my statement at the beginning that we want the public to have full faith in the efficient operation of our county board. The public is not going to have full faith in the efficient operation of our county board if we look like a disheveled mess. If we look like a circus, people are going to think we're a circus. So one of the ways that we can avoid looking like a circus is to treat our board meetings with a level of formality. That doesn't mean suit and tie, tuxedo. No, what I'm talking about, though, is a process where we recognize that we are going to treat matters according to Robert's rules. We are going to act in a fashion that raises the level of formality associated with these meetings, and we're going to conduct business in a manner consistent with state statute, consistent with board rules, consistent with Robert's rules. And so these pointers are very important in my mind in giving the public faith that we are doing things the right way within our county. William raised an issue. Robert's rules for reconsideration contain provision for the motion to reconsider to be separate from the action of reconsideration in situations where notice is required. You are absolutely right, William, because there are special rules about whether it's previously noted on the agenda or not noted on the agenda. You're absolutely right, and there's a different vote requirement process for that. So that is exactly what we're talking about when it comes to the motion for reconsideration. Thank you for pointing that out, is that Robert's Rules does address the situation where we can't surprise somebody with a motion to reconsider at a meeting subsequent to the meeting where we originally took action on a particular item. Avoid duties of the chair. I cannot emphasize enough how important the chair's responsibility is in the context of parliamentary procedure. One of the ways that I think there's another disconnect between Robert's rules and counties and frankly local governments within Wisconsin is the role of the chair. Robert's rules says that the chair has to be completely neutral, is not to engage in debate, and doesn't vote unless there's a tie. That's not consistent with our representative democracy because the county board chair is the county board supervisor who was elected that position by the people who put that person in that seat. And so they are entitled, the electorate is entitled to representation on the board. And representation means that the board chair ought to be debating and voting to represent the constituent interests of the people that voted for that particular board chair. So in a circumstance where we have a board, I think a board chair should always vote. I think that a board chair can engage in debate if it's limited, not extensive debate. But if the board chair finds him or herself in a situation where they have strong feelings on a particular topic, that's the opportunity for the board chair to pass the gavel to the vice chair, take a seat amongst the rest of the county board, and engage in vigorous debate. Once that process is done, once that motion is disposed of, the topic of which is of particular interest to the board chair resumes the seat as board chair, and the vice chair hands the gavel back to the board chair. Motions and misconception. There's absolutely no requirement in Robert's rules that we ask for nominations 3 times. And in fact, we can vote for anybody we want. Nominations are just a way to show support. So we're not limited in terms of who we can vote for as to whether that person was nominated or not. Elections, there is no procedure in Robert's rules to eliminate the lowest vote getter. If we have, for example, 4 people running for vice chair and we do not have a majority of the board voting for one particular candidate, there's no process for removing the lowest vote getter. So I wouldn't do it. I don't think it's a good rule. Your board rules can say you do that, but I don't think that's a good idea. The reason being is we don't know how the process is going to play out, and it may be that the board coalesces around some sort of compromise candidate for the position, which may have been the lowest vote getter on the first round of voting. Motion to lay on the table. I talked about the misconceptions surrounding the motion to lay on the table previously, how it's always confused with the motion to postpone to a definite time. Let's not confuse those two. Again, the motion to postpone indefinitely kills the particular motion and it avoids any particular debate on the motion. If it is a really difficult subject, the motion to postpone indefinitely is a really, really powerful procedural tool. The motion to adopt an entire report, and I see this mistake made from time to time as well, is that when a particular committee chair or a department head, for example, provides a report to the board, I've seen the board say, move to receive the report and place on record. You got to be very careful about what you're doing with a particular report because unless you're 100% confident that the report is 100% accurate, we never want the report to be attributed to the full county board. And so even the motion to accept and place on record has certain danger. So I would tell you this, is that take a look at your board rules and take a look at the way that you typically do things within your county. Have a conversation with your corporation counsel about some of the legal dangers of adopting reports or the particular vernacular or terminology you use when a report is made and the body accepts it, because we don't want that entire report to be attributed to the county board unless that is our specific intent. All right, I'm pausing here for a second because we have another question that came in from Alexander. There are a few bodies with members appointed by a county board, but are not exactly committees of the board. For example, lake districts, library board, etc. To what extent do those bodies have the authority to create their own rules? It's clear they're bound by state law, but it's unclear whether they would have the ability to adopt different rules. I think it depends on the type of body, Alexander. I mean, honestly, I think that if we have an independent entity such as a sanitary district or a library board, that they have a level of independence separate and apart from the county board where they can adopt their own rules. We have appointment authority over certain positions on those particular boards, but we do not have control, so to speak, over those boards. Contrast that with our regular standing committees, a human services board, and so on. We have authority or control as a county board over those entities, so we can make our board rules applicable to those committees. I talked about friendly amendments. Kim, absolutely. Great question. We talked about friendly amendment and how that vernacular should not exist. If you want more information about the categories associated with these rules, what they do, what they don't do, why they exist, I've pasted a link here to where a lot of the information came from. All of the information came from Robert's Rules. But if we look at Robert's Rules, and I'm going to, thankfully, I keep it on a shelf next to me here. If you look at Robert's Rules, it's a thick book. This is a thick book. And it's very small print when you start reading through that thick book. So it's not exactly light reading when we're getting prepared to go to bed. So I like sources like this because they have a way of distilling the really important information into a digestible format that we can then understand. And again, maybe it's just me, but I have such a better understanding of all of these rules if I understand why they exist. And so it's awesome to look at sources like this and start asking the question, well, why would it be that way? Why is it that we do things? It can't just be purely random, and it's not. The rules of procedure are designed, going back to the very early part of this discussion, to recognize the rights of the majority, the minority, those who are there, those who are absent, and all of them in between. And so understanding these rules of procedure and its protection of those various constituent interests, I think, leads to a better understanding of the rules of procedure. So what about public comment? Again, the slides are in the slide deck, and please read through these. But there are special rules about public comment. And I'll say this, there are any number of topics that proceed before county boards now that generate all sorts of really vigorous, really pointed, and in many circumstances, toxic debate from the public. All right. We've got to be very careful about how we treat public comment. First and foremost, there is no state law that requires us to have public comment on our agenda. There's some state law that requires certain topics be subject to a public hearing, our budget, zoning issues, things like that. We have to have a public hearing. But as a general rule, there is nothing that says we have to have public comment on our agenda. So given that, we have the ability to fashion rules surrounding public comment, rules of decorum and expectations for the public when they are speaking to the board. And so I would really, really encourage counties to work with corporation counsel on developing the rules of the game surrounding public comment. Now, why do you want to work with corporation counsel? Because there are legal issues that are baked into this whole concept of regulating public comment. At least in the United States, we have this thing called the First Amendment. And that First Amendment can be tricky when it comes to application to public comment periods. So work with your corporation counsel on a lot of these public comment rules and so on. So We've reached the 1 hour time limit. I will stay on as long as you all want me to stay on in terms of asking questions. But now I'll turn it back to you all and see if there are any questions you have. And while I'm going through some of the ones that have been posted here, Sarah, I'll ask if I missed anything that you think is particularly important, because I know you've had several discussions with counties and in the context of your county officials workshops and so on about parliamentary procedure and rules of procedure. All right. Shabana says, do you have any recommended guidelines for public hearings for those issues that you mentioned? Absolutely. Um, there is a template set of county board rules that I worked with Sarah on, and WCA published. I believe it's on their website. If not, just shoot us an email. We'd be happy to send those to you. And within those board rules, we have a set of guidelines for public comment. The only thing I will say is that that set of guidelines is neither comprehensive nor entirely correct, depending upon the situation within your county. So take those guidelines, have a conversation with Corporation Counsel and your county board leadership about what are the rules of the game when it comes to public comment. But yes, we have those within the template board rules. Jackie asks the question, will the PowerPoint slides be available? Absolutely. The PowerPoint slides and a recording of this discussion is going to be posted to WCA's website. That's wicounties.org under past event materials. Shabana says hearings, though, not comment. Oh, are there rules, guidelines for public hearings? I'm sorry, I misread that as public comment. Um, I don't have any template rules for public hearings, but I've seen different things in different counties. I think that's a great question. It gets a bit beyond today's discussion because depending upon the nature of that hearing, if it's a contested case, for example, when we're dealing with a zoning issue, there might be particular rules at play. If it's a public hearing on the budget, there might be other rules. And so I don't have a template, but I'd be happy to have a conversation with your corporation counsel about what those rules might look like. And we're happy to gather resources from other counties. So Sarah, what did I miss? You always find something. What did I miss?
Andy, there's just one thing I want to mention and or have you talk about, and that's the concept of unanimous consent.
Yes,
Simply
that is a
because
really
it comes up oftentimes, I think, when we talk about suspension of the rules. And so I just wanted you to mention a little bit about the concept of unanimous consent.
one of the things that I like to see is the efficient use of time in these meetings. So if there is a procedural mechanism that will save us time, I really encourage counties to take a look at that procedural mechanism. One of them is to use a consent agenda or consent calendar. That saves a tremendous amount of time. But another way is asking for a particular item to be adopted by unanimous consent. All that means is that on a matter that appears to have zero opposition, the board chair can say, is there any objection to the adoption of X or Y or Z? Hearing none, it's adopted. That's by unanimous consent. Now, I will tell you that under Wisconsin law, we have to have the maker of the motion, the seconder of the motion recorded, and the outcome of the vote. So unanimous consent, if it's adopted without objection, that means everybody voted yes. That is the procedural outcome of adopting something through unanimous consent by the chair asking if there is an objection. And if there is no objection, then it's adopted by unanimous consent. If there is an objection, then we just have to go to a vote. And all it takes is one person saying, I object, then it has to go to a vote. All right, other questions or
I think you have
points?
another question here, Andy, under the Q&A.
Let's see here. Oh, can a county supervisor make a motion to place an item on a future county board meeting agenda with a majority vote, or is the only method available a written request signed by a majority of the board as specified in state statute? All right, two different concepts. I believe that the rules of procedure, Robert's rules, allow a supervisor to make a motion to place an item on a future board meeting agenda. And if a majority of the supervisors agree, vote yes on that motion, it's on the agenda for the next meeting. I think that's in order under Robert's rules. Of course, that can be modified by your local board rules. So talk to your corporation counsel about that particular question. The second part of that question talks about the written petition process to call for a special meeting under section 59.11 of the statutes. In that particular statute, a majority of the supervisors have the ability to sign a petition to ask that the board hold a special meeting. That petition has to contain the items of business that will be considered at that special meeting. So those are two circumstances where an item that is not otherwise on the agenda can be forced onto an agenda for a future meeting.
All right, Andy, I'm not seeing any other questions. If anybody else has a question, I was going to say you can type it in now. And while we're waiting for those other questions to pop in, I just want to mention that our next In the Boardroom will be held on August 26th, where we will talk about the property tax collection and foreclosure process. So if you're yearning for more information, that's the term, Andy, that's the term you used in
I know I used the word
write-up, in the
I
write-up that
used the word
everyone
yearning
will.
and Sherry made fun of me.
I know. Andy comes up with these write-ups for the magazine and we get a chuckle out of them. But if you find yourself yearning for more information on the property tax collection and foreclosure process, join us on August 26th. Andy, that gave us another time. I think we have another question from Kim in the Q&A. I mean,
All right.
in the chat. Sorry, it's in the chat.
Before I get to that, let me say this too about the August discussion. We have Mike Schlock, the Calumet County Treasurer, that's going to join us for that meeting. So make sure all of your treasurers, corporation counsel, and others are aware of that in the boardroom session because we've had quite a bit of activity in our court system dealing with property tax foreclosure process. So I think it's going to be a great discussion. I, for one, yearn for that discussion. I hope others do too. So Kim asks, where would a supervisor make such a motion to place something on a future agenda as we don't have an agenda item for making such a motion? Does it occur anytime the board is still meeting? That's a great question, Kim. I get asked that question all the time. I think as long as the board is still meeting, that motion would be in order. It doesn't really fit nicely under any item on a typical county board agenda. I know there are some counties that have an item on their typical agenda. This is future agenda items. It would obviously be appropriate there, but I think that as long as there's no other business pending before the floor, as long as that member obtains the floor, we talked about that, and then makes that motion, it's seconded, it can go to a vote, and I think it is in order at that time.
Andy,
All right.
that's all the questions I am seeing in the Q&A in the chat.
Fantastic. We've got a bunch of Robert's Rules experts out there now. I look forward to talking with them at some point about the elegance of Robert's Rules. That's awesome.
With that, Andy, thank you so much, and thank you to everyone who joined us today. And we hope to see you back on August 26th.
Thank you all.